Labor Law of Cambodia, 1997, Indemnity for Dismissal, Damages, and Mass Layoff. Article 89, if the labor contract is terminated by the employer alone, except in the case of a serious offense by the worker, the employer is required to give the dismissed worker, in addition to the prior notice stipulated in the present section, the indemnity for dismissal as explained below. 7 days of wages and fringe benefits if the worker's length of continuous service at the enterprise is between 6 and 12 months. If the worker has more than 12 months of service, an indemnity for dismissal will be equal to 15 days of wages and fringe benefits for each year of service. The maximum indemnity cannot exceed 6 months of wages and fringe benefits. If the worker's length of service is longer than 1 year, time fractions of service of 6 months or more shall be counted as an entire year. The worker is also entitled to this indemnity if he is laid off for reasons of health. Article 90, indemnity for dismissal must be granted to the worker and, if applicable, he can also claim damages even though the contract was not terminated by the employer, but the latter, through his evil actions, pushed the worker into ending the contract himself. If the employer treats the worker unfairly or repeatedly violates the terms of the contract, he also has to pay indemnities and damages to the worker. Article 91, the termination of a labor contract without valid reasons, by either party to the contract, entitles the other party to damages. These damages are not the same as the compensation in lieu of prior notice or the dismissal indemnity. The worker, however, can request to be given a lump sum equal to the dismissal indemnity. In this case, he is relieved of the obligation to provide proof of damage incurred. Article 92, when a worker has unjustly breached a labor contract and takes a new job, the new employer is jointly liable for damages caused to the former employer if it is proven that he has encouraged the worker to leave the former job. Article 93, any worker who was engaged to furnish his services may, upon expiration of the contract, demand from his employer a certificate of employment containing primarily the starting date of employment, the date of departure, and kind of job held, or, if applicable, the jobs held successively as well as the periods during which the jobs were held. The refusal to supply this certificate obliges the employer to pay damages to the worker. The certificates supplied to workers are exempt from all stamp and registration tax, even if they contain items other than those mentioned in the preceding paragraph, as long as these items do not include any bond, receipt or any agreement liable to ad valorem duties. The phrase free from all engagement and all other terms indicating the normal expiration of a labor contract, the professional qualifications and the services rendered are included in this exemption. Any harmful statement that could prejudice the employment of a worker are formally prohibited. Article 94, without prejudice to the provisions of Article 91, the damages owed in the case of a breach of the labor contract without valid reasons, as well as those owed by the employer as per the provisions of Article 89 above, are determined by the competent court and based on local custom, the type and importance of the services rendered, the worker's seniority and age, the pay deductions or payments for a retirement pension, and, in general, on all circumstances that can justify the existence and the extent of the harm incurred. Article 95, any layoff resulting from a reduction in an establishment's activity or an internal reorganization that is foreseen by the employer is subject to the following procedures. The employer establishes the order of the layoffs in light of professional qualifications, seniority within the establishment, and family burdens of the workers. The employer must inform the workers' representatives in writing in order to solicit their suggestions, primarily on the measures for a prior announcement of the reduction on the affected workers. The first workers to be laid off will be those with the least professional ability, then the workers with the least seniority. The seniority has to be increased by 1 year for a married worker and by an additional year for each dependent child. The dismissed workers have, for 2 years, priority to be rehired for the same position in the enterprise. Workers who have priority for rehire are required to inform their employer of any change in address occurring after the layoff. If there is a vacancy, the employer must inform the concerned worker by sending a recorded delivery or registered letter to his last address. The worker must appear at the establishment within 1 week after receiving the letter. The labor inspector is kept informed of the procedure covered in this article. At the request of the worker's representatives, the labor inspector can call the concerned parties together 1 or more times to examine the impact of the proposed layoffs and measures to be taken to minimize their effects. In exceptional cases, the minister in charge of labor can issue a procas, ministerial order, to suspend the layoff for a period not exceeding 30 days in order to help the concerned parties find a solution. This suspension may be repeated only 1 time by a procas of the ministry.